sorry, this is part 2 of chapter 6. I got cut off. So we know federal courts are established under the United States Constitution. The federal district court, which is the trial court, hears 2 types of cases. Federal question cases, which is a claim based on the United States Constitution, federal statute, or treaty, and you can see that in the text on the bottom of page 144. Diversity cases are when the plaintiff and defendant are citizens of different states and the amount in dispute exceeds $75,000. Both of that criteria must be met in order to bring a diversity case in federal court. Okay? There must be diversity of citizenship, right? Plaintiff and defendant are citizens of 2 different states, and the amount in dispute exceeds $75,000. Examples of appellate courts are United States Court of Appeals and the Supreme Court of the United States. Let's talk about litigation. What are pleadings? They're papers that begin a lawsuit. The pleadings in a case are the summons and complaint, and they begin or start a lawsuit once they're filed. The complaint is a short, plain statement of the allegations and the legal claims, and this is served or delivered with a summons. An answer is a brief reply to the allegations in the complaint. A counterclaim, sometimes the accused party will initiate a second lawsuit in response to the first, and a reply is a brief reply to the counterclaim. What is discovery in a lawsuit? Well, once the summons and complaint is served, then discovery begins, an information exchange between the parties. Discovery allows both sides to uncover evidence, encourage a settlement without a trial, or ensure few surprises during trial. Interrogatories are written questions that the other party must answer under oath. These are all discovery tools once a lawsuit commences. Production of evidence. Each side may request to see each other's evidence. Physical or mental exams may be requested, where one party may request the court to order an examination of the other party if it's relevant to the case. A request for admission. Each side may request the undisputed facts be affirmed or denied to avoid wasting time on them. And e-discovery, each side may request certain emails, social media posts, and electronic information in exchange of e-discovery. With respect to trial procedure, the plaintiff has a burden of proof. The plaintiff must convince the jury that its version of the case is correct. In a civil case, the proof needs to be proven by a preponderance of the evidence, meaning at least slightly more likely than to be true. And we could quantify it by, say, 51%, more likely than not it's true. In a criminal case, the proof required is higher. It must be beyond a reasonable doubt, right? So if you were going to quantify it in numbers, it would be 100%. There are rules of evidence in trial procedure, and lawyers are allowed to ask only questions that are relevant to the case. First, the plaintiff must prove its case. It will put on its case. First, there are opening arguments. This is a brief summary given by each side of the facts they hope to demonstrate. Then the plaintiff will call witnesses. Questions to its own witness is direct examination. A lawyer only asks questions with helpful answers. Defendants will then question witnesses. The question to an opposing witness is called a cross-examination. Again, the lawyer asks questions with helpful answers. Then the defendant may move for a directive verdict, asking the judge to decide that the plaintiff has no case worth proceeding against the defendant based on the circumstances. So then, when the plaintiff is all done questioning its witnesses and the defendant's attorney has an opportunity to cross-examine, then the defendant may put on its case. The defendant will have opening arguments. The defendant calls its own witnesses. There are questions to their own witnesses on direct examination, and a lawyer will ask questions with helpful answers. Plaintiff has an opportunity to question the defendant's witnesses. Questions to opposing witnesses are called cross-examination, and then there are closing arguments by the defendant's attorney, which would be a brief summary by both sides, urging the jury to believe their side of the case. So each side has a closing argument, the plaintiff and the defendant. And at the end of the trial, the judge will give the jury instructions. The judge instructs the jury to evaluate the case solely on the facts of evidence presented that they've heard at trial. If the case is influenced by a certain legal presumption, the judge will summarize the facts to the jury. Then the jury will have an opportunity to deliberate and render a verdict. The jury discusses the case for as long as it needs, and sometimes the jury must be unanimous, other times only a majority vote is required. Okay, that's my summary, and I hope you have a great day.